Good evening, everybody. In the corporate litigation series, today we have a topic workplace litigation, employment rights, and legal challenges. In this particular topic, we are going to cover the different challenges the employees have during their work, like wrongful termination, like employment discrimination, like wage disputes, harassments, PF gratuities, pension claims dispute, whistleblower disputes. And now in a digital world, we have one more like a data privacy and data leakage allegations on the employees. Before we are going to begin, I'd like to immense pride to introduce our guest, Advocate Jayaprakash Somani sir. He is the CEO of GSS Supreme Legal LLP, President of a Rotary Club in New Delhi, President of Nani Palkiwala National Law Club, and author of more than 65 books, which is available on the Supreme Court leading case laws. Sir, we have been serving the nations as an advocate since 1989. With their visions, leadership, and dedication to legal education, NPNLC has formed a spread legal awareness across the nations. Thank you very much, sir. Over to you for the class.
Thank you. Thank you, Manoj, for your kind words. Friends, today we will cover so many things in so many parts. So, let me share you the document. I will share you a document, then I will speak. So what different type of litigation employees are facing in corporate field? Corporate workplace litigation in India, employment rights and legal challenges. Corporate workplace litigation in India arises from the dispute between employers, employee, workmen, trade union, directors, executives, contractors, and regulatory authorities. It covers with individual employment dispute such as termination, salary, harassment, and confidentiality, and collective and industrial dispute such as retrenchment, strikes, union disputes, and unfair labor practices. So as you know, I have different webinars for latest 4 new labor codes. So as the current legal framework, the 4 labor codes are now, which are already notified and enforced from 21st November 2025. That 4 codes are Code on Wages 2019, Industrial Relation Code 2020, Code on Social Security 2020, and Occupational Safety, Health and Working Condition Code 2020. Replacing the rationalizing 29 central labor law. So 29 central labor law replaced with these only 4 codes. So all these 4 codes includes all. So we have a different webinar on different codes already on YouTube, and in future also we will shoot after some valuable jurisprudence of the Supreme Court from Supreme Court side. Today I will not mix Hindi because portion is very exhaustive, comprehensive block is this, and if I start to elaborate in Hindi also, so it requires more time, and I have another webinar, so we will complete today's session in English to English only. So the transition must nevertheless be examined with the applicable rules, notification, saving clauses, and state-specific implementation framework. Then arises a question, what is the employee's legal status? This is often the most important jurisdictional question. What is the generally governed principally by labor legislation and industrial dispute mechanism. So try to understand these different legal status of different kind of employee. So I have elaborated first workman worker, which can be governed by labor legislation and industrial dispute mechanism. Second, managerial or supervisory employees may have limited remedies under industrial dispute legislation depending upon statutory definition and employees' actual duties. C. Executive director or senior management may primarily rely on employment contract, Companies Act, contract laws, principles of natural justice where applicable, civil remedies, writ jurisdiction in appropriate cases. The designation alone is not decisive. Court examine the real nature of duties and function. So this is a directorate only, not it is mandatory. It is directory. Then principal legal framework. So major rights are come from the Constitution of India. So Constitution of India is first legal framework. Important provisions includes Article 14, equality and non-arbitrariness. Article 15, prohibition of discrimination on specified grounds. Article 16, equality in public employment. Article 19, 1C, freedom to form association oblique union. Article 21, dignity, privacy and fair procedure. Article 23, prohibition of forced labor. Article 24, child labor protection. Article 39D, equal pay principle. Article 42, human condition of work and maternity relief. So remember that when you are claiming any human conditions of work and maternity relief, your plaint should be based upon the Article 42 and then the subsequent sections of that per one of the four codes. Then Article 43, living wage and decent conditions. Living wage and decent conditions. And Article 43A, workers' participation in management. For a purely private employer, Article 14 to 21 are not automatically enforceable in the same manner as against the state. However, constitutional values may influence statutory interpretation and may become directly relevant where a public authority instrumentally of the state or enforceable public law duly is involved. Then wrongful termination, unlawful dismissal. So wrongful termination means unlawful dismissal. So common forms. So on which point these dispute arises, dispute comes into existence. So termination without contractual notice, dismissal without a disciplinary inquiry, termination is violation of standing orders, termination based on malafide reasons, termination for whistleblowing. If anybody is trying to whistleblow on the corruption of that particular department, then management don't like that. So they can terminate for whistleblowing. Discriminatory termination, punitive termination disregarded as termination simplifier, illegal retrenchment, termination during protected statutory leaves, termination after reporting sexual harassment or fraud. So if any girl or any female employee is reporting under POSH Act, that time employer can terminate her. So this is illegal termination. So these are the common forms of wrongful termination or illegal termination. Which are the relevant law for this? The principal framework is now the Industrial Relation Code 2020, including its provision related to standing orders, grievance redressal, industrial disputes, retrenchment, layoff, closure, unfair labor practices. The code consolidate the earlier industrial relation framework. So earlier Industrial Dispute Act is also merged here. So many acts merge here, and the Industrial Relation Code 2020 is established now. So important legislation question: was the termination a genuine termination, simpliciter, or was it actually founded on alleged misconduct? If the termination is punitive in its substance, procedural safeguard may become critical. Leading case for this: Dipti Prakash Banerjee versus Satyanarayana Bose National Center for Basic Sciences, 1999, 3 SCC 60. Principle occurs in this case is the court examined the distinction between the termination simpliciter and the termination founded on misconduct. So for this distinction, this case laws is recommended to study it again. Then next, a retrenchment, layoff, and closure. A termination may be legally classified as retrenchment, dismissal, discharge, closure related termination, uh, redundancy termination, redundancy, redundancy termination. The Industrial Relation Code contains the statutory framework for layoff, retrenchment, and closure. The precise requirement depend on the nature and size of the establishment and the applicable statutory provision. Example: a company closes one division and terminate 200 employees without following the applicable statutory procedure. Potential issues: whether the closure is genuine, whether the termination constitute retrenchment, notice and compensation, government permission required where applicable, compliance with standing order. So these points should be noted. These points should be focused while you are drafting or arguing the plaint before the labor court, industrial dispute court, or in appellate court also. Then 6, remedies in wrongful termination. What are the remedies in wrongful termination? Depending on the legal status of the employee and the forum, possible relief may include reinstatement. Reinstatement means to join that job again, back wages, continuity of services, consequential benefits, compensation in lieu of reinstatement, damages, setting aside of dismissal, fresh disciplinary inquiries. Leading case: Deepali Gundu Survase versus Kranti Junior Adhyapak Mahavidyalaya. Citation 2013 10 SCC 324. The Supreme Court explained that a wrongful termination causes reinstatement with continuity and back wages may be the normal rule, subject to the fact including employment elsewhere and other relevant circumstances. The court has also emphasized that relief is not mechanically automatic in every case. So every case is a different. So as per the case, as per the fact, court is giving the remedies. You can claim that remedies. But remember, the different class employees have a different forum. So labor court is for labor worker like that, and for employees, floor employees, or you can managerial employees, they have the different forum. Civil code they have, some have the NCLT also. Okay, if corporate is there like that. 7, employment discrimination claim. Discrimination may arise from gender, disability, pregnancy or maternity, caste, religion, race or ethnicity, age, sex orientation or gender identity, sexual orientation or gender identity, retaliation, for exercising statutory rights. Relevant laws: Constitution of India, Code on Wages 2019, Rights of a Person with Disability Act 2016, Maternity Benefit Act 1961 as applicable within the current statutory framework, POSH Act 2013, applicable state shops and establishment legislation. The Code on Wages expressly prohibit gender discrimination in wages and conditions of the employment of work for the same or similar nature. So this is very important output from this discussion. There should not be a gender discrimination, male female like, and male have the more wages and female have less wages. That should not happen now, because there is a parity now. There is a equal work, equal pay, like that. So leading cases, some leading cases I'm mentioning here: Air India versus Nargesh Mirza, citation 1981, 4 SCC 335. The Supreme Court examined discriminatory service conditions imposed upon women employees. Anuj Garg versus Hotel Association of India, citation 2008, 3 SCC 1. The court rejected paternalistic restrictions on women's employment and applied constitutional equality principles. Then McKinnon, Mackenzie and Company Limited versus Andrew D'Souza, D. Costa, citation 1987, 2 SCC 469. Important authority concerning equal remuneration and gender discrimination in employment. Then 8, wage and salary dispute. Common dispute includes what are the dispute grounds on wage and salary dispute. So, non-payment of salary, delayed wages, minimum wages, deductions, overtime, bonus, equal pay, variable pay, commission, incentives, salary duration during suspension, final settlement. The Code on Wages 2019 deals with minimum wages, payment of wages, wage deduction, bonus, related claims. Relevant provisions include the framework under Chapter 226, including Section 318, 3 to 18, and provisions related to the claim and enforcement. For example, the employer pays an employee below the applicable minimum wage by describing part of the remuneration as an allowance. The legal question may be whether the payment structure lawfully satisfy the statutory minimum wage requirement. Leading case for this: State of Punjab versus Jagdish Singh, citation 2017, 1 SCC 148. The Supreme Court held that in appropriate circumstances, temporary employees performing substantially similar duties may claim parity in wages, subject to the applicable legal requirement. So temporary employee should have the right to take the equal pay as a permanent employee. But it requires some applicable legal requirements. So case to case, this is a different. But many times, temporary employee also can get the equal pay as a permanent employee. So lawyer should have to fight this battle in well manner. 9. Harassment and hostile work environment. The workplace harassment may include sexual harassment, bullying, stalking, threats, humiliating conduct, abusive workplace culture, repeated discriminatory conduct, retaliation, cyber harassment, sexual harassment. The statute is the sexual harassment of women at workplace prevention, Prohibition and Redressal Act 2018. I have just taken one webinar on this POSH Act. Separate webinar is there on YouTube channel on criminal law side. So this is appeal from my side to the viewer to see that webinar to understand entire sexual harassment of women at workplace prevention, prohibition, redressal act. It is called POSH Act. Important provisions include Section 3, prohibition for sexual harassment, Section 4, internal committee, Section 9, complaint, Section 11, inquiry, Section 12, interim relief, Section 13, inquiry report, Section 14, false or malicious complaint, Section 16, confidentiality, Section 19, employer's duty. Leading cases Vishaka versus State of Rajasthan, citation 1997, 6 SCC 241. The Constitution Bench laid down binding workplace sexual harassment guidelines before enactment of POSH Act. So before enactment of POSH Act, this Vishaka and State of Rajasthan's guideline was working at in that era. Then Apparel Export Promotional Council versus A.K. Chopra, citation 1999, 1 SSC 759. The court recognized the seriousness of workplace sexual harassment and the need for effective protection of women employees. Aurelino Fernandez versus State of Goa, citation 2023, SCC Online SC 621. The Supreme Court emphasized effective implementation of POSH framework and institutional compliance. So, POSH framework and institutional compliances guidelines regarding that you can read in this judgment, Ornelindo Fernandez versus State of Goa. Now, 10 number, a breach of employment contract. So typical dispute involves notice period, salary in lieu of notice, appointment terms, bonus, incentive plans, stock options, relocation clauses, confidentiality, termination clauses, garden leave, repayment of joining bonus or training expenses. Example, an employee resigns after receiving a joining bonus subject to a 12-month service condition. The employer seeks recovery. The issue may include whether the clause is a genuine contractual obligation, whether it is a penalty, whether the amount is reasonable, and whether the employee actually breached the agreement. So these are the standard question of laws. So your plaint or your appeal should be based upon the substantial question of laws, and in High Court and Supreme Court you need substantial question of laws. There is my separate video on substantial question of laws for SLP, how this substantial question of law is framing like that. The Contract Act 1980, Contract Act 1872, especially Section 10, 23, 27, 37, 39, 55, 73, and 74 may become relevant depending on the dispute. 11. Non-compete clauses. Non-compete clauses. Section 27 of Indian Contract Act 1872, agreements in restraint of trade are generally subject to strict scrutiny. So when you are getting sign of employee on the contract of employment, so restriction clause should be very reasonable. So you cannot restrict to any employee permanently to join any other firm or permanently to leave from your office. You cannot restrict permanently, but reasonable restriction can be there, like a 3 years restriction, 2 years cooling period before joining another same type of firm. So such type of restriction you can put. Leading cases related to this, Superintendence Company of India Private Limited versus Krishnan Murgi. Citation 1981, 2 SCC 246. The Supreme Court examined post-employment restraint and Section 27. Percept Demark India Private Limited versus Zahir Khan. Citation 2006 for SCC 227. The court reaffirmed the strict approach to post-contractual restraint of trade. Practical principle, confidentiality obligations may be enforceable even where a broad post-employment non-complete clause is vulnerable. So when there is no reasonable restriction clause is there, unreasonable restriction if you are putting, so that a particular clause can be said wide, can be said wide. So that it depend upon the interpretation by the court. Then 12, confidentiality and trade secret. So many organizations are getting signed the confidentiality agreement or trade secret. You cannot leak your trade secret to opposite parties or to your competitors. So corporate employees dispute often involves customer database, source code, pricing information, business plans, technical know-how, trade secret, confidential documents. Potential remedies may include injunction, damages, contractual enforcement, protection of confidential information. Litigation strategy, a company may establish: one, what information is confidential, how the information was protected, how the employee obtained it, what act constitute misuse, the loss or risk of losses. A generic clause standing that all information is confidential may be the less effective than a carefully drafted confidentiality policy and access control system. Then, just to give me 1 second. So, friend, uh, retaliation and victimization. Retaliation may follow reporting fraud, reporting sexual harassment, filing a wage claim, joining a trade union, giving evidence in an inquiry, raising a safety concern, reporting regulatory violations. Example, an employee reports accounting fraud to the audit committee and is dismissed 2 weeks later. If such type of things happens, so this comes under the retaliation and victimization. So the employee may argue the dismissal was pretextual, there was victimization, the employer breached its whistleblower policy, the termination violated applicable labor law or contract, the termination was retaliatory. The factual sequence is often critical. Then 14, industrial and labor disputes. The Industrial Relation Code 2020 covers trade union, standing orders, grievance redressal, industrial dispute, conciliation, adjudication, arbitration, strike and lockouts, layoff, retrenchment, closure, and unfair labor practices. The code specifically contains chapters dealing with grievance redressal, standing orders, industrial dispute resolution, strikes and lockouts, and retrenchment closures. Leading case, Bangalore Water Supply and Sewerage Board versus A. Rajappa. Citation 1978 to SCC 213. The Constitutional Bench developed the famous industry test for industrial dispute jurisprudence. The precise statutory position must now be read with the current industrial relation code. So there is a so many common things between current code and last industrial dispute act. So some are very new provisions are also. So in my separate block on that particular code, you can uh, was there, you can understand from that particular webinar. Then 15, Provident Fund dispute. The Provident Fund litigation may concern coverage, employer's contribution, employees' contribution, excluded employees, wage components, damages, interest, recovery, contract employees, applicability to establishments. The current statutory framework is contained in Chapter 3 of the Code of Social Security 2020, dealing with the Employees Provident Fund. So remember that in current code, Chapter 3 is related to the Employees Provident Fund. Chapter 3 of the Code on Social Security 2020. So I have already elaborated that code in near about 1.5 hours or 2 hours. So when this code get passed from the parliament in 1920, that time itself I have shooted one webinar on that. And after the codification recently in the November 2025, when it is applicable, after that also you will get my separate webinar on all these four codes. So leading case related to Regional Provident Fund Commissioner to West Bengal versus Vivekanand Vidya Mandir. Citation 2019-18 SCC 200. The Supreme Court examined the meaning of the basic wage and whether various allowances should form part of the PF contribution base. Example, an employer pays a fixed monthly special allowance to an employee but excluded it from PF contribution. The issue is whether the payment is genuinely variable or is essentially part of the basic wage is substance. Then gratuity claims. Gratuity dispute may concern. This is very vast field, friends. This labor code, labor law practice is very, very vast field. It covers corporate, and it covers government sectors also. It is very, it requires very huge uh, preparation, which mental condition to read these different type of case laws. Now new code, you can compare to old acts also. So like that. At least you should spare at least 2 to 3 hours daily on this practice. That time you can get the command on this labor code practice. We are handling all these cases in Supreme Court, so we know that we how to handle this. So after a labor court, that is industrial tribunal, or you can say it is a labor tribunal. After labor tribunal, appeal goes to the High Court, and after High Court, appeal comes to Supreme Court under Article 136. Gratuity, qualifying service, uh, continuous service, resignation, retirement, death, forfeiture, misconduct, calculation of last drawn wages, delayed payments. The Code on Social Security 2020 contains the gratuity framework in Chapter 5. Earlier, Chapter 3 is related to the Employees Provident Fund, and Chapter 5 is related to the gratuity. Important principle, gratuity is the statutory social security benefit. An employer cannot simply withhold it because the employee was left employment. So even though employee left the employment, employer cannot withhold the gratuity amount. He have to release it. Leading case, Jaswant Singh Gill versus Bharat Cooking Coal Limited. Citation 2007 1 SCC 663. The court considered the relationship between statutory gratuity rights and forfeiture in the context of misconduct. 17. Pension and retirement benefits. Dispute may involve pension eligibility, qualifying service, family pension, pension revision, delayed pension, commutation, recovery from pension, pension after disciplinary proceedings. Leading case DES Nakara versus Union of India, citation 1983, 1 SCC 305, the foundational pension case concerning equality and the social security character of the pension. Practical point, retiral benefits are often treated differently from ordinary contractual claims because statutory pension right may have a continuing and protective character. Now, occupational health and safety, OHS. So, safety and health working condition code 2020 is now the central framework for workplace safety and health. It comes into force on 21st November 2025. Important provision includes section 6 employer's duty, section 10 to 12 accident, dangerous occurrence or disease reporting, section 14 employees right, section 18 safety and occupational health standards, section 22 safety committees and safety officers, section 23 employer responsibility for health, safety and working conditions, section 24 welfare facility, section 25 to 32 working hours, holiday, overtime and annual leave, section 43 employment of women, and provisions concerning contract labor and migrant workers also. So gig workers, migrant workers also covered in this occupational health and safety conditions. So all four labor law are now labor code now recognize the contractual laborers also and gig workers also and migrant workers also. They also have the equal right as a regular workers. The statutory framework express addressed employer's duty, employees' right, occupational health standard, and safety committees, working hours, overtime, and welfare facilities. Example, an employee suffers an injury because safety equipment was not supplied, a dangerous machine was not maintained, statutory safety procedure were ignored. Possible consequences may include statutory compensation, regularity action, criminal liability, civil claims, and employment related legislation. Then 19 whistleblower protection cases. So if some employee is whistleblowing blowing the corruption, he is disclosing the corruption of his employer to the particular authority, that is called whistleblower. So whistleblower should get the protected. So whistleblower protection cases. Whistleblower dispute may involve corruption, accounting fraud, securities violation, workplace safety, regulatory non-compliance, misuse of company funds. Corporate framework. Listed companies are also governed by securities law and corporate governance requirement, including mechanisms for whistleblower complaints. The Companies Act framework also contain provisions related to fraud, corporate governance, audit committees, directors' duties, investigation. Practical legal challenge. India does not have one universal private sector whistleblower statute providing a comprehensive remedy for every retaliatory termination. Therefore, the case may be required a combination of Contract, Companies Act, securities regulations, labor law, public policy, and constitutional law where applicable. Example, an employee reports financial fraud to the audit committees and is subsequently dismissed. The strongest case may be based on timing, internal whistleblower policy, documentary proof of the complaint, discriminatory treatment, and deviation from normal termination procedure. Then 20, privacy and employee data protection. Very, very important. And this new law, Data Protection Act, comes from the Putta Swami case. So Putta Swami case is also one of the leading case in Supreme Court AOR examination. So privacy and employee data protection. Corporate employees routinely process Aadhaar related information, PAN, bank details, salary data, biometric data, health information, CCTV footage, access logs, email communications, performance records, background verification information. Constitutional privacy, K.S. Puttaswamy retired versus Union of India. Citation 2017 10 SCC 1. The Supreme Court recognized privacy as an fundamental right under Article 21 and Part 3 of the Constitution. Digital Protection Data, Digital Personal Data Protection Act. Digital Personal Data Protection Act 2023. We will shortly undertake one special different program to explain all the provisions, all important provisions with proper case laws, with proper practical guidance in one webinar. So Manoj, note down this point. In future, as early as possible, we have to take one webinar on Digital Personal Data Protection Act 2023. The DPDP means DP Data Personal DP Data Protection, DPDP Act. So the DPDP framework is relevant to the processing of digital personal data by employer, subject to the statutory scope, commencement and applicable rules. Key compliance questions: what data collected? Why is it collected? Is the processing lawful? Is the employee informed? Who has access? How long is the data retained? Is it shared with vendors? What security safeguards exist? So all the answers of this question you will find in that act. These are practical questions. Example, an employer uh, secretly monitors personal employees' communication unrelated to the business purposes. Potential issue may include privacy, proportionality, employment policy, data protection compliance, and contractual obligation. So personal communication, employer cannot focus on personal communication. Employer cannot interfere in your personal communication. So because that is your privacy right as per that Puttaswamy case. And as per this now data personal DPDP Act, Digital Personal Data Protection Act. Then 21, leave and benefit disputes. A common dispute concern earned leave, sick leave, maternity benefit, paternity policy, disability leave, adoption leave, leave encashment, public holidays, overtime, health insurance, bonus, retirement benefits. The applicable law depends upon employment classification, establishment, applicable state laws, employment contract, company policy, statutory framework. The current labor code framework includes social security benefit and working condition provision, while the OSH code, Occupational Safety Code, specifically addresses annual leave and working hours. Now, most important benefit, that is maternity and pregnancy related employment claim. Benefit, discrimination due to pregnancy, refusal to reinstate, maternity benefit calculation, a leading case, Municipal Corporation of Delhi versus female workers muster roll. Citation 2003 SCC 224. The Supreme Court adopted a beneficial interpretation of the maternity protection and recognized the importance of the maternity benefit for women workers. 23. Disability related to employment litigation. The Rights of the Person with Disability Act. This note down this point also, Manoj. In future, we have to take separate webinar on rights of personal with disability Act 2016. It relevant to discrimination, reasonable accommodation, reservation, employment protection, promotion, termination following disability. A leading case, Vikash Kumar versus Union Public Service Commission, that is UPSC, citation 2021 5 SCC 370. The Supreme Court strongly emphasized the concept of reasonable accommodation and substantive equality for persons with disability. So persons of disability should get the reasonable accommodation. They should have a separate their toilets. They should have a separate access. There, along with the step also, along with step, there should be such type of access so they can carry their wheelchair easily. So such type of infrastructure should be there. So this guidelines is given in Vikas Kumar versus UPSC. Then 24 corporate workplace litigation, typical litigation process. Stage 1. What is the process of litigation? Corporate workplace litigation. What is the litigation process? So first step, internal grievance. When dispute arise, then internal grievance, HR complaint, complaint to your HR, then compliance complaint, then audit committee, then internal committee under POSH Act, then grievance redressal mechanism. And if satisfactory solution is not get there, then second stage, statutory or regulatory forum. Depending on the dispute, labor authority, conciliation officer, industrial tribunal, EPFO authority, gratuity authority, ESI authority, civil court, NCLT in appropriate corporate matters, and high court. Then stage 3, appellate and constitutional remedy. Possibly rooted may include Possible routes may include statutory appeal, High Court under Article 226, Supreme Court under Article 136, civil appeal, special statutory appeal. Then Supreme Court jurisprudence core principles. So what are the core principles of Supreme Court jurisprudence for the labor law matters? The Supreme Court has developed several important principles: substance over designation. The real duty of an employee must matter more than the title printed on the appointment letter. Natural justice. A disciplinary action affecting employment should ordinarily follow a fair procedural where the applicable law requires it. Proportionality. Punishment must not be shockingly and disappropriate to misconduct. For social justice, labor and employment legislation is frequently interpreted as a protective legislation along with the statutory text remain decisive. Then back wages are fact sensitive. Wrongful termination does not automatically result in a fixed formula of full back wage in every case. So we have to struggle to get full back wage. Then privacy required proportionality. So employees monitoring data processing should be assessed against the purpose, necessity, and safeguard involves. So all these jurisprudence is developed by Supreme Court in labor law cases. The statutory benefits cannot be contractually eliminated. So statutory benefit cannot be contractually eliminated. You cannot eliminate by forming the contract statutory benefit. If you do that, that is a wide contract then. Employment contract generally cannot lawfully waive mandatory statutory rights. Then it courts examine the real nature of action. The termination called resignation acceptance, non-renewal, or termination simpliciter may be examined for its true legal character. Now, there is a chart of the cases, important Supreme Court cases, quick reference. Here is a subject, middle is case and citation. Wrongful termination and back wages. You can find this explanation regarding wrongful termination and back wages in Dipali Gund Survase versus Kranti Jyoti Adhyapak Mahavidyalaya 2013 10 SCC 324. Termination simpliciter and punitive termination Dipti Prakash Banerjee versus SN Bose Center 1999 3 SSC 60. Judicial review of the disciplinary action BC Chakravarti versus Union of India 1995 6 SCC 749. Natural Justice Managing Director ECIL versus B Karunakar 1993 4 SCC 277. Industrial establishment Bangalore Water Supply versus Rajappa 1978 to SSC 213. Equal pay State of Punjab versus Jagdish Singh 2017 1 SCC 148. Gender discrimination Air India versus Nargis Mirza 1981 4 SCC 335. Equal remuneration Macklin Mackenzie versus Andrew DeCosta, 1987 to SCC 469. Woman at Workplace, Vishaka versus State of Rajasthan, 1997 6 SCC 241. Workplace harassment, K. Chopra versus Apparel Export Promotional Council, 1999 1 SCC 759. Maternity benefit case, MCD versus female workers muster roll, 2003 SCC 224. Pension related matter, DS Nakara versus Union of India 1983 1 SCC 305. Provident Fund related matter, RPFC versus Vivekananda Vidya Mandir 2019 18 SCC 200. Gratuity related matter, gratuity related guidelines is in Jaswant Singh Gill versus Bharat Cooking Coal Limited 2007 1 SCC 663. Non-compliant superintendence company versus Krishnan Murgai 1981 2 SCC 246. Post-employment restraint precept Demark versus Jair Khan 2006 4 SCC 227. Privacy KP privacy guidelines KS Puttaswamy versus Union of India 2017 10 SCC 1. Disability accommodation Vikash Kumar versus UPSC 2021 5 SCC 370. Reservation equality Anuj Garg versus Hotel Association of India 2008 3 SCC 1. Then 27. How to build a strong corporate workplace case. How to build strong corporate workplace case. This is very important part now for lawyers. So for the employees, preserve evidence. Employee should preserve this evidence, appointment letter, salary slips, emails, HR complaints, appraisal records, termination letter, attendance records, medical documents, PF and gratuity records, and witness details. Establish the timeline. A strong chronology may show complaint, investigation, adverse action, termination. The sequence may be critical in retaliation case. For the employer, maintain because sometime you can be a lawyer of employee, so you can guide how employee should keep the record, and sometimes you are the lawyer of the employer when you are undertaking the corporate consultancy. In that case, yeah, because our Manoj Kumar is taking corporate consultancy. Manoj Kumar, who have host this webinar today, he is my associate in Supreme Court of India, and he is very devoted in this corporate law practice. And recently, through our JSS Supreme Legal LLP, we are taking only 5 companies, 5 corporates as a turnkey consultancy project. So we are turnkey, give them consultancy related to the different type of drafts related to the internal sub dispute arises to internal redressal mechanism. Then if matters arise, then concerned labor court, concerned in labor tribunal, then appeal to High Court, then appeal to Supreme Court. We are handling in Supreme Court as a law firm, but we are giving full support to that particular corporate. So 5 companies only at a time we are handling. If anybody want to understand what we are doing in corporate consultancy like that, so any employer can contact to Manoj Kumar, Manoj Kumar or to our LLP numbers. So we can guide how you can maintain the record, how you can be a safe from any litigation like that. So for employer, maintain written employment contracts, clear policies, disciplinary procedures, post compliance, whistleblower mechanism, data protection policy, safety records, wage and PF compliance, documented performance management process. A company often loses litigation not because conduct did not occur, but because a procedure and evidence were poorly documented. So what type of procedure should be there? How company should maintain all record so that all evidentiary documents will get on time. Now, I am concluding this session with concluding remark. The corporate workplace litigation in India has become a multidisciplinary field involving employment contacts, labor law, constitutional rights, corporate governance, data privacy, workplace safety, social security, anti-discrimination law, and statutory regulatory mechanism. The most important practical question is in every dispute is what is the employee's legal status, what status govern the relationship, what exact right has been violated, and what forum has jurisdiction. These 4 points are very important while deciding the forum. A strong workplace litigation case is built on correct classification of the employee, applicable statute, documentary evidence, procedural fairness, and timely remedy, precise relief. For employers, the best defense is preventive compliance and documentation. And for employees, the strongest case usually depend on the providing the legal rights, the legal breach, the casual connections with resulting prejudice. This is a general legal research overview. So friends, this is the our total today's webinar. So I have taken only in English to English because they're very exhaustive and very comprehensive information was there, and we have limited time in our hand. So we have completed there. Uh, Somebody has sent the message. I have joined late, sir. But don't worry, you will get the link of this video. Life member of Nani Palikwala National Law Club, you will get the link of this video only on that group. If you are the member of that group, then you will get the link. If you are not member of that group, then you have to join that member. Life membership is only 500 rupees for 20 years. So be a life member and get the privilege on all our webinars. Yeah, recently we are taking near about 2 to 3 webinars in a week, and all webinars are recorded, and all records you will get on YouTube also, and some records are from the course also, so different course on my app, so you can visit and see the app also, and you can find so many courses are there. So even though this era is of the AI era, but AI can give the information, AI cannot give you the knowledge. Knowledge is always given by any teacher, any guru. Guru bina jnana nahi. Information you can gather from different sources. You can gather from newspaper, you can gather from different blogs, you can gather from AI by giving proper prompt, you can get the information. But you cannot get the knowledge unless until you are in connection with correct guru. So if you are joining as a life member of Nani Palkhiwala National Law Club, then Nani Palkhiwala National Law Club is taking regularly these steps and elaborating. And in future, very recently in future, we are organizing now one group which is called Judgment Analysis Group. So we will start that group, judgment analysis. What is the exactly structure of that group? I will tell you. First of all, we will charge at initial stage monthly fee only. Monthly fee only. So we will charge, suppose 100 rupees or 200 rupees, not more than 500 rupees. Only this is a different group. Huh? Only that person should join these groups who are interested in discussion of judgment analysis, because in the era of AI we are losing that patience to read the judgments, so we don't know the judgment. We can get only through AI related citation and related paragraph only, and we are putting beyond that we don't nothing. Then how we can get the legal acumen in future if such type of lazy atmosphere is there? Hmm? AI is good. Take the help of AI. But original judgment we should read, not whole, but analytically we should read. So we are forming one NPNLC legal analysis group, a judgment analysis group. Very soon you will get that link. You join that on monthly basis first, and then we will give it year subscription also in future. And once in a week, we will hold that session. Suppose we are going to take that session on date 5. Then before 3 days, you will get the judgment in that group on which we are giving analysis. So you have 3 days to read that judgment. And if you are interested to take the part in the judgment analysis, then you just give your name. Okay, yes, we are interested to take part in this as a speaker in this judgment analysis. Suppose 4 persons have given their consent as a speaker, then we will distribute that judgments part to different person, and collectively we will elaborate that judgment, and conclusion I will do myself, concluding remark. And if nobody is ready to do the judgment analysis task, then I will explain you entire judgment step by step. That particular session maybe go beyond 1 hour, beyond 2 hour also. So there should not be a timeline for that. There should be only legal analysis of judgment. You know that judgment is the practical application of law. And in one judgment, you can see the practical application of law thoroughly with its different citation. So in one judgment, you can get 5, 6, 7, sometimes 10 citation also. From this side is some citation, from that side some citation, and the remark of judges on that particular citation also. Okay, so such type of brainstorming session to protect our brain intact even in the era of AI also. So that is our struggle for that. Okay. And if we keep that free of cost, it will get no value, because today's program is free of cost, no value is there. So judgment analysis program will be paid, but on monthly basis. In start, we will charge not more than 500. We will sit together. We'll see if 200 is correct or 300 is correct. So not more than 500 will charge fee for 1 month, and weekly we will analyze one judgment. And that judgment should be a current affair judgment. If current affairs is going on, some strikes are going on, some issues are going on any particular judgment of Supreme Court, that particular judgment we will take analysis. And when there is a no any current affair is going on, then we will take the leading cases like Keshwananda Bharati, like Minerva Bill. We will undertake that, or okay, this K.S. Puttaswamy judgment, okay, Delhi judgment also, then tribunalization judgment also. There are 88 that is leading cases in AWAR examination. I have books on that AWAR examination on Amazon, Flipkart. You will get that books. So so many judgments are there, but gradually we will take that. We will take that. And what is the motto of this judgment analysis group? To be familiar to legal language. We should speak proper legal language in proper gesture, in with very polite nature. Argument should not be aggressive. Argument should be a convincing. If we are able to convince the judges, you will get the very, very fantastic result in your matter. So that is our motto, and that is our target under this judgment formation group. So now I will Manoj, you can now unmute yourself and now conclude this session.
Thank you all the participants, and thank you, sir. We have a truly grateful for your time and the constant guidance. Thank you, sir, for the joining us today for the despite a busy schedule and given us such a elaborate about the implied conflicts. Thank you very much, sir.
Yes, thank you, thank you. Now I have 7:30 to 10:30 one webinar, 7:30 to 10:30, and meanwhile I'm going to darshan of the Noida Iskon temple, because today is Ekadashi. I have kept the fast of Ekadashi, and in our Maharashtra this is Ashadi Ekadashi. This is the biggest Ekadashi, biggest. All over Maharashtra people are keeping this fast on Ekadashi. So I am getting 1 hour meanwhile. So I'm going to Noida temple, and then I will come back, and then I will undertake that 3.5 hour. Maybe that particular webinar will last for 4 hours. So that is a challenging task for me today. Thank you.
Thank you
Thank you
for
very much.
this schedule you have taken out such a time.
Yes,
Thank
yes,
you.
thank you. Thank you.